Hi, my name is Mineh, and I'm a part of group number 2. We are going to be talking about gender discrimination in the workplace. So what is gender discrimination in the workplace? It is the mistreatment of individuals in their employment specifically due to their gender. This could be done through hiring, firing, promotions, pay inequality, job classification, and benefits. The first case law that demonstrates gender discrimination is Merritt versus Old Dominion Freight. This case addresses sex stereotyping, corporate culture of discrimination, and the plaintiff is Deborah Merritt. Defendant is her employer, Old Dominion Freight Line, Inc., which is a nationwide trucking company. This case was argued January 27, 2010, and decided April 9, 2010. So what happened in this case? Merritt worked as a line haul truck driver, and she performed her duties without any issues. She was an excellent employee. She became interested in becoming a pickup and delivery driver due to the flexible hours that position would provide her. She filled in numerous times as a pickup and delivery driver in order to prove that she was fit for this position. Although she expressed her interest in becoming a truck driver, the company hired less experienced men over her multiple times. So why wasn't Merritt hired? Her manager told her that they could not let a woman hold that position because females are more inclined to get injured while on the job. Also, no female drivers in the city had ever held the position of pickup and delivery drivers. Finally, Merritt applied again, and this time she did get the job. However, she was placed on a 90-day probationary period. She could lose her job at any point if she did the slightest thing wrong. Her male counterparts were not held to the same standards as her. She held this position for 2 years, and she eventually sustained an ankle injury while on the job. Her doctor gave her a clean bill of health after 2 months and advised her to get back to work. However, the company decided to evaluate her on their own terms by giving her a physical ability test. This test was divided into 6 components that mainly measured her overall endurance, her cardiovascular health, and it was mainly focused on components of her health that wasn't really related to her ankle. Therefore, it was a very unfair evaluation. And also, she ended up failing this test and got terminated because of it. She eventually filed a charge of sex discrimination with the EEOC and then proceeded with a lawsuit in federal court in Western District of Virginia. She claimed that she was terminated due to her gender, which was a clear violation of Title VII. The district courts granted judgment against Merritt, claiming that there was a legitimate reason for firing Merritt because she failed the PAT, and also there was no evidence of discriminatory animus. Merritt appealed this decision. When she took this case to the Court of Appeals, they sided with her, claiming that there was a record as a whole supports Merritt's claim that a jury could find that discrimination on the basis of gender was afoot. In other words, this charge was unworthy of credence and it was definitely unfair. She was able to prove that there was evidence of discriminatory intent because male employees that got injured were not given the PAT, and also there was no policy requiring any of the employees to take the PAT test in the first place. The PAT test was established in order to test potential hirees, and this was only done on a variable basis. We definitely agree with the Court of Appeals judgment because there was definitely discrimination against Merritt due to her gender. The PAT test was given to her in order to make it seem like she was getting terminated for a reason other than her gender, but it was clear that she was held against completely different standards as her male counterparts.
All right, my name is Josh. I'm going to talk about case law number 2, Johnson versus Transportation Agency. This case has to do with gender discrimination and sex stereotyping. The plaintiff is Paul Johnson, the defendant is the Transportation Agency, and the case was argued on November 12, 1986, and it was decided on March 25, 1987. The facts of the case are, the agency announced a vacancy for the promotional position of the road dispatcher. None of the 238 positions in the permanent skilled craft worker job classification, which included the dispatcher position, were held by a woman. The agency decided to promote Dan Joyce, a woman, over Paul Johnson, a man, both of whom were equally qualified. The claim, held by Paul Johnson, is that the transportation agency, an affirmative action employer, took into account the sex of the applicants for the promotion decision. Johnson received a right to sue letter from the EEOC and sued through the Federal District Court on the basis of the violation of Title VII. What was the agency's affirmative action plan? Their plan was to hire minorities and women voluntarily through a statistically yearly improvement in hiring and promoting these minorities and women in job classes that are underrepresented with no specific number in mind. What did the court decide? The court decided that the agency took into account the sex of the applicants in the promotion decision, which violated Title VII of the Civil Rights Act of 1964. The agency's plan was invalid under criterion decided in Steeler v. Weber that the plan be temporary. The Court of Appeals reversed the decision, deciding that the agency appropriately took into account Joyce's sex as one factor in determining that she should be promoted. The plan was moderate and flexible as a case-by-case approach to effecting a gradual improvement in the representation of minorities and women in the workforce, which is fully consistent with Title VII of the Civil Rights Act of 1964. As a group, we completely agree with the Court of Appeals decision.
Hi, my name is Kimberly, and I will be discussing case law number 3, Fortner versus City of Boca Raton. This was a sexual harassment case. The plaintiff is Fortner, the defendant is City of Boca Raton. They argued on March 24, 1998, and they decided on June 25th, 1998. Facts about the case. After Fortner resigned as a lifeguard, she brought immediate actions against the City of Boca Raton and her immediate supervisors, claiming that her supervisors have created a hostile atmosphere by touching inappropriate remarks and comments, claiming that this was violation of Title VII of the Civil Rights Act of 1964. Title VII is a conferred jurisdiction upon the district courts of the United States to provide injunctive relief against discrimination in public accommodations, authorize the Attorney General to institute suits to protect constitutional rights in public facilities and public education, prevent discrimination in federally assigned programs, and establish the Commission on Equal Employment Opportunity. The courts decided in favor of Fortner. The city was also held liable for the supervisor's actions. City had failed to disseminate its policies against sexual harassment amongst the employees. Can an employer be held responsible under the Title VII? The courts decided yes. Yes, the court was held that such liability is subject to an affirmative defense looking to the reasonableness of the employer's conduct as well as that of the plaintiff victim. As a group, we decided in favor of the courts and Fortner because the city didn't prevent the hostile environment for its employees.
Hi, I'm Zoe, and now I'll be talking about Microsoft and how they faced discrimination charges in 2015. Now, plaintiff Katie Mazuris, who was a former employee at Microsoft for 7 years, sued Microsoft based off of systematically discriminating against female tech professionals. Now it is known that the workplace at Microsoft is consisted of 76% male, and 88% of them are at the executive level. So there's no doubt that Microsoft's workplace is male dominated. Now the claims are that female tech professionals are compensated less than men, promoted less favorably than men, and evaluated less favorably than men. Now, as a group, we believe that there's definitely a gender gap issue at Microsoft, and they should address this issue and find solutions into recognizing and valuing these female employees. And the first step to creating this equality is through having diversity committees to help develop a well-defined diversity inclusion program, so that women and men are being treated and evaluated fairly, as well as implementing a clear criteria for evaluations.
Hi, my name is Annie. Today I'm going to talk about the Chipotle, which is happened in 2016. So the fact is there have 3 women to sue the Chipotle that's discrimination against the female employees. And all these 3 women claiming that regardless of performance evaluations from this company, and male employees treat better and retain their jobs, and more often than their female counterparts. And they have wrongly determined it by the managers. So I think workplace anti-discrimination policy enable employers to discipline employees who participate in gender-related discriminatory behaviors, and also serve to protect the employer should a discrimination lawsuit arise. And they should have the women leaders, which can break down the stereotypes. And finally, just like what Zoe said, they need more diversity organizations, and which is to create a well-defined diversity and inclusion program. And here is our references.